Good evening, everybody, and welcome to a special meeting of the Board of Selectmen. I don't think this will be a very long one, but it's one that I think we needed to call. The town has followed all the proper channels with regard to the Board of Education issue that's ongoing, and we have reached out and filed to the Freedom of Information Commission, I think twice now, to get an expedited ruling on this. We think time is of the essence, especially with the budget right around the corner. And twice they said they can't get to it, and I think for a couple of months. So that's a problem. And so due to the fact that the Democrats on the Board of Education have ignored their own bylaws, which we can point to, they have ignored state law and Board of Education precedent. We have no other choice than to ask our council here to seek injunctive relief in court. We cannot let this go on that long. And as I said at the last meeting, lots of other entities are watching this and concerned that if something like this is let stand and procedures, precedent, and law is not followed, then what are we doing? As I've mentioned since the beginning, since back in the summer, I could care less who the chairman is. It doesn't affect my life or my job one iota. But I do care about the process and about what this would do, disregarding that process to our state, to our town government. So with that, before I call for a motion, if my colleagues have a question of me or Ben Bianco.
Lauren, do you?
Good, Janet.
All right, well, so first a point of information, and then I do have a response to what you just said, but you know, as this meeting was posted, it mentioned a restraining order. For the non-lawyers in attendance, could counsel explain what is intended by that?
So this is Ben Bianco, and what that means is that we would ask a court to enjoin certain members of the board from taking certain conduct, i.e. seating members that are not proper members, from not seating members that are proper members, in order to put the board back where it should be in the town's opinion with respect to the conduct that took place on October 21st of this year, and then further after that at meetings where there were no quorums based on certain members not actually being members yet forming the quorum. So it would be to ask the court to instruct or order the certain board members to act in accordance with the law.
Right, then with that, I do have a response. I've more than once requested a written legal opinion that unequivocally establishes that the Board of Selectmen has legal standing to take action against our Board of Education. I've not received one. Without a sound legal basis, I will not support any legal action against our Board of Education. It's not in the interest of Greenwich Public Schools or our taxpayers to engage in an expensive, protracted legal battle solely for the purpose of installing your preferred Board of Education candidate. This legal action is unnecessary. A complaint has already been filed with the Freedom of Information Commission. Now that the Board of Selectmen has embarked on this path, we need to let that process play out or dismiss the complaint. It's the responsibility of the Board of Selectmen to serve the interests of the entire Greenwich community. If this board takes the legal action it has proposed, it will be unprecedented. No process should be used by one board to intimidate another. There will certainly be unforeseen consequences that will be harmful to our schools. Opening yet another legal process only takes resources and distracts from the business of educating our children.
Thank you for the scripted response. I can go off script and just tell you, we did not start this. We were not the ones who had a lawyer threaten the town. We were not the ones who hired a lawyer to sue the town with our own taxpayer dollars. We were not the one who ignored their own bylaws which clearly states that the town clerk has to swear in a member of the Board of Education
Or designate somebody to swear them in.
or designate. We are not the one who ignored state law, the 24-hour posting notice, and claimed there was an emergency when there wasn't. And that emergency excuse changed several times. We are not the one who ignored precedent, where I don't remember, and I've been in government a little longer than you, ever a town entity, one party ignoring the wishes of another. I've had people calling me up saying, this has never happened before. And they had plenty of other choices. If they didn't like what the one person they found, the one objection one is the one they put in there. And for what? For what, Janet? For a tie break? The chairman doesn't even have a tie-breaking vote on this, right? You picked a fight, they picked a fight, and you know what? We're not going to ignore the state law. We're not going to allow that. And maybe you need to talk to some other people in other branches of government who are very concerned about what they did. So the Board of Selectmen is actually defending the people of the town of Greenwich. And I will take that position all day long. We are right. We have state law, we have precedent, and we have their own bylaws statement. And of course, as I mentioned the last time, I could have acted on day 31. 94 days later, it's clear, very clear, I did not want to get involved with this. I don't think any of us did. But for political purposes, just circle the wagons because your own party is telling you what to read and what to say. And
No, wait.
let me finish. You are the one reading off of a script. I don't have to do that because I know what this law is. I know what happened here. It's in my mind. I don't need to read off of a prepared statement. Again, you're the one that always talks about process and you're completely ignoring it. Lauren hears from you all the time at the meetings about process. Why are you ignoring it now?
I am still as focused on process as I've ever been. And your words about my script are completely unnecessary and unfair because you know, because you've seen me at every meeting, I always read from a script. These are my own words. No one has put words in my mouth.
Not always. Not always. But again, your statement there, I take offense to. We're being political. No, we're not. I mentioned right off the bat, and you were at that meeting, you heard that I received a letter from their lawyer that, by the way, they didn't even get permission from the other elected members who happen to be Republicans, right? So that would be like just one group saying, hey, we're going to take it into our own hands and hire a lawyer to sue the town, and the heck with those other Republicans who, by the way, had more votes than they did in the last election. The people spoke and they keep ignoring it. So this is the mother of all power grabs, and for no good reason. And to do this on the Board of Education when your sole purpose should be to educate the kids in the best possible way, it's embarrassing. It's embarrassing, and it's not going to stand. So I'm ready to take a vote whenever either of you are ready. Lauren, do you have a statement or do?
I don't have a statement. I had a question of Mr. Bianco. Can you just again, and I think Janet, you had the same question. Just maybe just a little bit more detail. We take this vote and then what occurs? Because I'm just wanting to replay that for myself.
We would file for a restraining order in court, and we would ask, and it would be, I mean, again, we have to work out exactly what we're going to specifically ask for based on, as even Janet said, the law, which we will absolutely follow. But we will ask the court in aid of the FOIA commission complaint, because they have obviously decided not to act, in aid of that complaint, to rectify and to restrain certain board members from acting outside of the law and, as Fred said a couple times, their own bylaws, and seating members that aren't members because they have to be sworn in and weren't, not seating members that were sworn in, and to put us back to where the law demands. And if the FOIA commission ultimately decides that it was a legal meeting, then that will be unwound, but that's incredibly doubtful. All the case law and precedent, it weighs heavily against that was actually an emergency meeting. And so in order to try to preserve that and not have to unwind months and months worth of votes and some critically important votes, we would ask the court to follow the clear law and issue restraints against certain conduct in order to put the board back in order.
So does the board go back to, not having, either Jen or Paul seated? Or is that would be something that would, for the courts to decide?
Yeah, yes, that would be for the court to decide, but I believe initially, and again, it hasn't been filed yet, and I obviously have to deal with my client, the town, and exactly what is going to happen, but the easiest way to obtain a restraining order is to put back the board into status, what lawyers would refer to as status quo in a restraining order, which would have been where the board was before the illegal conduct started. And so at that point, it would be to not permit Ms. Behet from participating, but also not to permit Mr. Capiali from participating, which would put us basically back where we were. Now, it's almost certain that we, especially, and then at that point, by the way, we may even go back to the commission and say, okay, look, the board has been put back in order. We still need your ruling, which is a binary ruling. It is absolutely shouldn't take more than 10 minutes, quite frankly, because it's purely illegal meeting, purely illegal ruling by the FOIC. Was there an emergency? You have the two excuses, which, as Mr. Camillo said, we're changing. But regardless, they'll probably consider both of those excuses. And does either of those excuses constitute an emergency? It is a binary up and down vote. And we will ask to say, look, the board has been put back. It really does need an eighth member. And an eighth member was properly appointed by Fred. And we would probably go back and ask the court, or ask the FOIA commission to rule. And if they didn't, we may then go back and say, okay, well, now we really need the court to rule because the FOIA commission is not acting. So that's why I say the process is still a little bit up in the air. We would take that all up in front of the court, but it really is what the court is willing to do. But as an initial matter, yes, I believe what we will try to do is put back status quo.
Got it. Thank you. That's helpful. And just from my experience being on the board, and when I do sort of pay attention, and I'm not saying I don't pay attention to things, most of the votes that the board takes are not 4-4. Really the only one is the chair, which, as Fred pointed out, since the chair does not have tie-breaking ability, is not as doesn't have the same impact as the BET. I think most votes are probably 5-3, 6-2, 7-1. So I'm not really sure, because I know people are talking about these important things that are happening, but in my experience, and maybe someone's going to send me an email where that isn't the case, I think the majority of the votes are a majority approved. So I'm thinking about it from that lens as well. So that's kind of where my mind's at.
And if you want me to respond, Lauren, I again, I don't follow the board that closely, as you know. I do follow the board and have in the past, but I would say that it really still is, again, up to the town and up to the judge. But yes, I mean, if you have a 7-0 ruling, and assuming that it's only 7, or you have a ruling that's very far to one side or the other, I don't think that anyone would go in and try to disrupt that. I mean, conceptually they could, because if a proper member was not seated, that person, if that person is Paul, could argue that, look, I wasn't allowed to participate, so therefore the vote wasn't legal. I don't think that's going to happen, Lauren. I don't think that's anyone's intent here. I think the intent here is that if you do have a close vote, and there are some politically charged close votes, especially when it comes to budgetary issues, that those should be done by actual board members and proper board members. And if it's a very close vote where either certain proper board members were excluded or improperly seated board members were included, I think that you have an incredibly well-founded argument to say that that vote was absolutely not legitimate, not proper, and not legal.
Thank you. Thank you.
So I still, as a non-lawyer here, find it confusing that we're opening up a second process. Is there any possibility, and this is a soft question because I think there is, that the judge would say that we have to let the FOIA commission make its ruling before any legal action can be taken? Is there?
Janet, that is possible. And so just to take it back for a second, I understand that there are a lot of non-lawyers in the room, but there is a similar concept when, say, you have an arbitration clause in a contract and it mandates arbitration. But if the breach of that contract by one party creates a circumstance where the remedies are going to be very difficult to either get an arbitration, or if the arbitration is so far down the line that the remedies will be ineffective, then you can absolutely go into court and seek what's called an injunction or a restraining order in aid of arbitration. And that would be essentially what we would initially be going on here. You would go for a temporary restraining order, a restraint in aid of the commission's decision, because, or the commission's action, because if the commission doesn't rule for several months, and a lot of things, as I just discussed with Lauren, can be done that are going to be very difficult, if not impossible, to unwind, so that the relief sought will not be, it's called essentially irreparable harm. The harm cannot be repaired reasonably or rationally because too many things would have to be unwound. So that is a possibility, but there is a lot of precedent to support something in aid of a commission or an arbitral decision. But I would also comment, I don't know if you listened to the audio, but there were several commissioners that said, oh, well, some of the things they're seeking here are more appropriately sought in court. I mean, that's what at least one member of the commission said. I don't have the transcript and I still, quite frankly, don't have the order, but one of the commissioners even recognized the fact that, unwinding these things and deciding who is the appropriate board member is not really something in the commission's purview. So we would also be making that argument based on the audio that I heard from the commission in addressing the second request for an expedited hearing, which was considered on November 20th, almost a week ago tomorrow.
Thanks, Ben. Any other questions? There was another question at the beginning of that from Janet, I think.
And council answered.
Yeah. Okay. All right. All right. Seeing no other comments or questions, is there a motion to ask the town to look into seeking injunctive relief in court to resolve this situation before it gets any worse and we get into the budget season and the battles really begin?
Certainly hate doing this. Lauren Raven, so moved.
All those in favor, Fred Camillo's yes.
You need a second. Hold on. Fred, you need a second.
Oh,
Yeah, you
oh.
need it. No one second.
Fred Camillo will second it. All those in favor, Fred Camillo is a yes.
Lauren Raven, yes.
Janet Stone McWigan, no.
Okay. Thank you. All right, thanks, Ben. Thanks, Ken. Appreciate your time, and for those who we won't see, have a happy Thanksgiving, have a safe one, and enjoy it with your families.
We need to make a motion to adjourn.
I was just getting to that.
Sorry.
Is there a motion to adjourn?
Lauren Raven, so moved.
Janet Stone McWigan, I
All
second.
those in favor, Fred Camillo is a yes.
Lauren Raven, yes.
Janet Stone McWigan, yes.
Okay, take care.